she was contesting that those were payments and she said something about that they were gifts.
So, ma'am, do you agree to give the father credit for the $24,800 that was provided through PayPal and Venmo?
Can you repeat that?
My attorney's on. My camera is not working on my laptop.
Okay.
I believe the parties agree as far as the amount that the pay record shows that the father owes of $21,777.14 in child support arrears owed as of yesterday, August 13th, 2023. The parties agree that the father paid $24,800 to the mother through PayPal and Venmo, which we have documentation of. The disagreement is whether or not there should be a judgment in the amount of $21,777.14. And then also the father is asking for a confirmation in the order that he's paid ahead by $4,020.71. The state's not in agreement to the judgment that he be paid ahead in that amount. So we would need a hearing on whether or not there should be a judgment of the $21,777.14 and whether or not there should be a reflection that he's paid ahead.
Mr. Smitherman, now usually we do in these kind of cases where people don't follow the rules is do a judgment for what was owed and then a release to kind of release the money. So at least the first issue would be we would do an order for judgment and then child support arrears of 0. What's your legal argument as to why we should not do that at the very least? And then we can talk later about any future.
Okay, Judge, I'm getting a little bit of an echo. So could you repeat how you said that y'all usually do it?
Usually we don't have an overage, number one, but so I don't want to talk about overage yet.
Okay.
I mean, I would still reserve that as for discussion later, but usually what we do is do a judgment of what's owed as of today on the pay record, and then a release of that amount, which sounds like it's going to be, it'll be like a 3-part deal. He owes $21,777.14 in a judgment. She's releasing that amount, which leaves an arrears of 0. Is he opposed at least to the first part to say that this is what's owed before any kind of credits?
Well, Judge, I believe that when Ms. Jackson was in the breakout room, she was contesting that those were payments and she said something about that they were gifts. What we have here is that in June of 2021, the parties came to an agreement for my client to pay her directly so that she could get the money faster. And so June 2021, the payments stop being paid through the AG's office, and then they start being made through Venmo or PayPal, then Venmo. At the time that the payments stopped, the Attorney General's pay record shows that my client had paid ahead. He had a credit of $4,287.50. And so going through that logic, we've paid, we've made the direct payments to her until they stopped until they started going through the AG's office again, which was, I think, halfway through March of 2023. So I don't, as far as saying that there's an arrears, I guess it's really semantics on whether we say that it's in arrears and then immediately released. But I don't know from what I've heard previously if Ms. Jackson is agreeing that those were child support payments based on what she said in the breakout room.
Okay. Are there any remaining children underage?
There's only one child between them. She's a junior, and so we've got roughly 2 years left.
Okay.
1 year. She graduates next May.
Okay.
Okay, so we don't have an agreement about whether the payments were child support payments. Because this is where we are. We haven't even agreed on that part.
Well, I don't know if somebody from the Attorneys General talked to Ms. Jackson when we were waiting. I just would like that clarified, to know what I'm agreeing to going forward.
I understand.
Judge, that's correct.
There were no court orders changing the registry of the court. They just decided to do something outside of court.
Yes, Your Honor. And what I believe in that August of 2021, she had actually, Ms. Jackson had actually submitted paperwork to the AG's office to stop child support services.
They didn't do a new court order.
No, I don't believe they did a court order.
Okay. All right, Ms. Phillip, do you want to call witnesses or do you have?
Yes, Judge. I'll go ahead and call the mother, Shaquina Jackson. Ms. Jackson, could you state your full name?
Shaquina Derisa Jackson,
And ma'am, what's the name of the child that you have with Cory Hodge?
Courtney Alexandria Hodge,
And how old is the child?
16.
And ma'am, will she be a senior in high school this year?
She will be beginning her junior year.
Okay, so she still has 2 years left of high
Yes.
school. Okay,
Yes,
okay. And ma'am, I'm gonna share my screen so that you can see a copy of the pay record involved in this case. And ma'am, I'm gonna scroll up to the top so that you can see the pay record. Ma'am, does this look like a true and accurate copy of the pay record in this case, showing all payments received through the State Disbursement Unit?
yes,
Okay. And ma'am, if I scroll down to the bottom, where it shows what was owed as of August 1st, 2023, is it correct that as of August 13th, 2023, basically yesterday, that the father owed $21,777.14 in arrears for child support? Is that correct?
according to the State Disbursement Unit, yes.
Okay. The state offers a copy of the pay record as State's Exhibit A.
Any objection?
Judge, the only clarification I'd ask for is when we were talking with the AG's office, they did mention that there were a couple of months on hold because of the status of these cases. So I believe June and July, they have payments on hold that aren't reflected in that pay record sheet.
Okay. State Exhibit A is admitted.
Okay. Miss Jackson, did you and the father, Cory Hodge, come to an agreement in June of 2021 that he would start paying you directly for child support?
Yes, we did.
Okay. And ma'am, did he start paying you through Venmo and PayPal?
Yes,
Okay. And ma'am, I'm going to share my screen to show a copy of the pay record for Venmo. I'm going to scroll down to just show that payments were made between Mr. Hodge and you. Is that correct?
yes,
Okay. And these are the payments that were made through Venmo?
yes, ma'am.
Okay. And that was basically, it looks like December 9th, 2022 through 4 days ago.
No, I think it was from 4 days from whenever this screenshot was taken.
Yes, that's correct. Sorry, excuse me. Ma'am, I'm going to share a copy of the PayPal receipts that were made to you from Mr. Hodge. Is this a true and accurate copy of the PayPal receipts?
Yes,
Okay. And ma'am, is it correct that he paid you through PayPal from December 2022 through August 2021?
yes,
Okay. And ma'am, to your knowledge, are all of those direct payments totaling 24,800?
I did not do the math, but I'm assuming so.
Okay, so ma'am, do you agree to give the father credit for the 24,800 that was provided through PayPal and Venmo?
Can you repeat that?
Yes, excuse me. Do you agree to give the father credit for the payments made through PayPal and Venmo?
I do not agree.
Okay, and can you tell the court why you don't agree for him to get credit for those payments?
Okay. One thing I wanted to clear up is Mr. Smitherman said we came to an agreement because of me getting the payments on time. We actually came to an agreement because he wanted to get the information off his credit. And so he came to me and asked me that. And so that's why. And then recently, well, not recently, maybe January, February-ish, we did get into a disagreement, and he basically told me that if I went through with this, that I wouldn't be getting as much as I'm supposed to get because of how he's paid. How he's paid, it doesn't reflect all the income that he really makes. So in order to save myself, and when I went looking and did the research, it said that payments not sent to the SDU wouldn't credit it. So that's why I said that and did not agree.
And ma'am, isn't it correct that you stated earlier that you had made an agreement with him for him to pay outside the State Disbursement Unit?
He came to me and I agreed to it, yes.
Okay. And ma'am, would you be in agreement to a judgment of $0 as of August 14th, 2023?
What does that mean exactly?
That would mean that he owes $0 as of yesterday.
No.
Okay. Pass the witness.
Mr. Smitherman?
Ms. Jackson, is Jackson your legal last name now, or is it Miles?
Jackson is my legal last name.
Okay, but you also go by Miss Miles?
That's my maiden name. I go by Jackson.
Okay. So when the payment records were showed, you understand that a lot of those notations in there state that it's for child support, correct?
Yes.
Okay, so is there any disagreement that the monthly amounts that he was making in approximately $600 every 2 weeks were child support payments?
Yes.
Okay, so you do agree that now there are some payments where he was reimbursing you for medical bills, and there's some birthday party notations on there. I haven't included those, or those aren't included in the total, but the ones that are referenced child support or abbreviated CS, you would agree with me that those are or were made for child support to you.
Yes.
Okay. And I'm just making sure that I heard you correctly, that you and Mr. Hodge did come to an agreement for him to pay you the child support outside of the Attorney General system.
Yes.
Okay. And once you made that agreement, Mr. Hodge started you paying outside of the Attorney General child support system. Is that correct?
Yes, he did.
Okay. And then at some point, y'all ended up having a disagreement. I think you said February or March, and then you ended that agreement. Is that correct?
He's actually the one who said, take me to court. So once he said that, I did go and refile to have it go through the system.
Okay. And so Mr. Hodges started to pay through the system again, like you requested.
Yes.
Okay. But you do not want to give him credit for the child support payments made in accordance with y'all's agreement?
No.
Okay. Pass the witness.
Okay.
No further questions for Ms. Jackson. The state calls Cory Hodge. Mr. Hodge, could you state your full name?
Cory Hodge.
Sir, is it correct that you owe $21,777.14 according to the State Disbursement Unit?
Yes, ma'am. I do have some objections because they've charged me interest on that amount, and you can see by the records I've never been late. So minus whatever the interest is what I agree to.
Okay, and Mr. Hodge, do you understand that according to your court order, you were ordered to pay through the State Disbursement Unit?
Yes, I understand that now.
Okay, and that whatever side agreement you made with Miss Jackson, that is not really recognized by the court normally, since there was not a court order that changed your order.
So that's something that I learned. So we came to an agreement, and Miss Jackson went to the child support office and dropped the case for monitoring. And the reason why that's important to me is I own a business and I'm trying to grow my business, and I have the child support case for not only Courtney but for my son Carson on my credit report. My ex-wife and Miss Miles both agreed to drop the monitoring and for me to pay them directly, so it would come off my credit report, which will allow me to get a little bit more flexibility financially to grow my business. So both of my kids' mom, which one is not a part of this course, dropped it around the same time within 30 days of each other. So I wasn't aware that it required a court order. I was just concerned about the monitoring because I'm gonna always pay and take care of my kids. So that's why it wasn't a concern for me. And I didn't know it was ignorance.
Okay. And Mr. Hodge, is it correct that you made those payments through Venmo and PayPal instead of through the State Disbursement Unit?
Yes, ma'am.
Okay. And sir, is it your position that you paid $24,800 to the mother?
Yes, ma'am. It was actually more payments sent, but some of that was for extra stuff like medical bills and for Courtney's sweet 16 birthday party.
Okay. And sir, would you be in agreement for a judgment to be taken of zero as of August 13th, 2023?
I would prefer at least to have the negative that I was when she stopped the monitoring. I think it was like 3,700 bucks that I had already paid through the system when she stopped the monitoring and the payment started directly. I don't want to lose that money.
And sir, do you understand that the court, normally we would not be able to say that you're paid ahead in that amount, since, you know, as of yesterday, you were not paid ahead in that amount?
Chris,
Okay.
I don't know if I understand the question.
Okay, I'll move on. Mr. Hodge, is there anything else that you want to tell the court?
No, I think I said it earlier. Around the same time, my ex-wife, she did the same thing. She dropped the monitoring on the case, pay her directly, have same records, bi-weekly payments directly, just in efforts to kind of grow my business. Things went south over $200 that I asked Miss Miles to pay for half of Courtney's hair, which costs well over $1,000. I asked her for $200, not to send me 200, just to reduce a future child support payment by $200. And this is why we're here.
Okay, pass the witness.
Mr. Smotherman?
Mr. Hodge, just to be clear, you understand that when the Attorney General is asking, you know, agreeing that you owe the amount of the 21,000 something, that is according to their records. That when you stop paying the child support through the disbursement unit, that ate up some of the I guess the credit that you had, and that from their end on their disbursement sheet that it shows that you owe 21,000 and some change. Do you understand that?
Yes, sir.
But it's also your statement that per the agreement that you had with Miss Jackson, that you have paid child support outside of the disbursement unit, and that you have paid her a total of $24,800.
Yes, sir.
And are you asking this court to give you the credit for all the payments that you made for child support in the amount of 24,800?
Yes, sir.
And based on those numbers, that 24,800 is more than the 21,000 that they are saying that that you are owed according to those records.
Yes, sir.
Okay, so you're in a sense you're just asking for credit for the amounts that you paid Miss Jackson in the amount of $24,800.
Yes, sir.
Pass the witness.
Okay, thank you. Ms. Phillip, I have a couple of AG technical questions
Okay,
regarding an overage. I guess the first question would be, is there some money on hold at this time that doesn't show up?
Judge, there is 2 payments on hold.
So typically when we have this problem, we do a judgment and those payments then are put on as a payment and Ms. Jackson would get the payment. And then
Judge,
yes, ma'am.
if we do a judgment of 0 as of August 13th, 2023, and then I put in my note that the money on hold is to be returned to him, I think the money on hold could be returned to him.
To Mr. Hodge or to Ms. Jackson?
Yeah, to Mr. Hodge.
Oh,
So I don't want any money
And
returned.
just, Cory,
well, the
hold on.
second question I have, Ms. Phillip, is if Mr. Hodge is asking for an overage, I guess, which does not include the money that's on hold, which I think by my calculation is $3,022.86. If we subtract the 24,800 from the 21,777 and 14 cents. So technically, I guess, are we able to do a judgment on the AG's pay record for that?
Judge, I've never had this circumstance come up before. I would say that we would not be able to do a future pay amount in the order, just because the pay record does not reflect that he's in future pay at this time. So I don't think we can put in the order that he's in future pay. I think the best that we can do is a judgment of 0.
Judge, if I may for a second, I believe what my client was about to say is that as far as the payments that are on hold, I'd actually contacted the Attorney General that I was dealing with, Lorna Beard, but I recently found out that she's now an associate judge with the court, so that explains why I didn't get any emails back. But we were actually trying to.
Mr. Smitherman, if I can interrupt you, the payments on hold, those are easy. The question, I guess, is what we do about the other parts.
Well, I guess so instead of doing a judgment for 0, I mean, what they filed was a motion to confirm support arrearage. And what I believe that you could do is do an order giving my client credit for the 24,800 and then denying their motion to confirm the support arrearage. And therefore you're not putting an amount of 0, you're just denying their request to confirm an arrearage, and you're giving my client credit for the 24,800 and applying those payments. Everything should work out to where it should have been in the first place.
Well, I think from the legal perspective, you're correct, but from the technical perspective, that's the problem. I think that's where I'm trying to make sure that this works, because we can legally put in the order of what we want to do, but then that doesn't mean the AG can enter it correctly. They have to register actual payments. The future pay, I mean, as far as what's on hold, that's easy. They'll get released. And I mean, we could, usually what we have is we have an ongoing obligation, then that'll just be sent to Ms. Jackson, and then it'll go as a future payment for the future. So let's say he paid 2 months of payments in advance, then his child support would end 2 months earlier at the very end, not right now, but at the very end. So that's not a problem. I don't think we have an issue with that as far as their computer system. The problem is whether or not I want to give him or can give him a future pay for the $3,000. There's no way for them to kind of enter that in as a future payment, because it's money they never received. I mean, definitely we can enter a zero judgment, but I can't. I guess technically we have a problem with the $3,000 as far as how they enter it on their computer system. The only other alternative I can think of, just as an option, I'm not making that as a ruling, but as an option would be that we abate child support for approximately 3 months, which that's about what I think child support is $1,090. Abate child support for 3 months, but that will mean that Ms. Jackson won't get child support for 3 months, and then restart up child support 3 months from now to give him that additional credit. That's not obviously the easy solution, but that's a way that the AG could say, okay, no child support for the next 3 months, start it up again on a certain date, and then he gets that $3,000 credit plus whatever is on hold applied to his account. Ms. Phillip, I guess, is that technically what we would have to do as far as those $3,000?
Judge, I would prefer that you do it that way, as far as saying that child support is 0 for 3 months and then start it again in November.
Okay, what is, tell me again, what is the amount that's on hold? If you,
Just 1 second, Judge.
Okay.
2,180.
say that again,
2,180.
2,000 or 3,000?
2,180.
Well, that's the only way that I can do it, Mr. Smitherman, I guess. We can enter a zero judgment as of yesterday. Then Ms. Jackson will receive the $2,180 in the next week or so from the AG for the overage. That would be counted as an overage for the future. As I instructed, it would probably be about 2 months earlier that child support would end. And the only way I can do it with the additional $3,000 is to say that child support should stop for the next 3 months. There'd be 0 child support. And then it starts again in 3 months. And then we're back on track basically at a 0 balance, maybe with an overage for the future, but still kind of a 0 balance. Is that what you and Mr. Hodge are asking for, Mr. Smitherman?
Yes, I mean, we're just asking to make sure that he gets the credit for what's been paid. So if that's the way that the court and the AG think that it can be done, then that'll work.
All right.
And just so, I got a question. So there won't be any issues if I continue, even though I got a 3-month buffer, to continue to make payments through the state's office, because I'm worried about my kid financially being okay. So even though she gets the 2 months, I still want to make sure that she has money available. So can I still make those payments through the disbursement unit and they'll disperse them?
You can always make additional payments for sure. She's
Okay.
got $2,180 here very soon, once they enter the court order on their system. Maybe let's say 1 to 2 weeks. You can always make additional payments, and for the future, you definitely always can. But that's, yeah. But you definitely shouldn't stop doing things outside of court, because that causes problems. I know you say you understood that, but that causes problems for a lot of people, because it only takes somebody to flip a switch to restart your child support. Then all of a sudden you're in the same situation you are today, wasting time, having to hire an attorney, and maybe losing money in the end. So there's a reason, just turning off the Attorney General's office's monitoring doesn't stop the court order. I could say for the most part, I think most judges agree that child support should be going through the State Disbursement Unit, even if it's a little slower, because we know that it causes problems for everybody when people don't do it that way. So you need to make sure you follow that. I think you understand that, but we want no hassle. And no hassle means paying it through the State Disbursement Unit, whether or not the Attorney General's office is dealing with your case or not. Okay. I think that's the only thing I can do to work around this is we're gonna do we're doing a judgment of $21,777.14. Well, no, I can't do it that way. It is not technically a release since Ms. Jackson's contesting it. Okay, I make a judgment of $0 as of August 13, 2023. I'm ordering the child support be abated based on an overage, and that the child support should continue again. Let's see, September. Is it December 1st or November 1st?
Let me count, Judge.
December
I
1st.
think it would be December.
Yeah, because he's not gonna pay. Well, I guess we gotta figure what happened with August. But has there been a payment, Mr. Smitherman, for August?
I'd
No,
have
sir,
to,
not yet.
Okay.
okay, so no payment for August. So if you're
Okay.
going 3 months, August, September, October, so start in November.
Yes, okay, that'll make sense. Okay, so payments will begin November 1st. You may, Mr. Phillip, you may need to add some language in there that it's for an overage. But payments to be abated and then begin again November 1st. Okay.
Judge,
Yes, ma'am.
the only issue that I see is I'm not sure if we'll be able to disperse the money on hold to Miss Jackson if there's no arrearage. Because normally if there's no arrears owed, I think it would go back to Mr. Hodge.
Okay, we'll have to just kind of wait on that and see. The overage, if it goes back to Mr. Hodge, then he'll know he got a payment back, and then Ms. Jackson didn't get it.
Well, for purposes of the hearing, I mean, we acknowledge and agree and consent to the payments that are on hold being released to Ms. Jackson.
They can try to work around it, but if it doesn't work, they can't do anything about it.
Okay,
So we'll just kind of wait and see on that. The abatement won't be affected by that. It's just whether or not Ms. Jackson's going to receive any money for the next 3 months. That's the problem, I guess.
okay,
I think Mr. Hodge wants to make sure she gets the money. So if he winds up getting refunded the money, he can always send it back. And then it'll get reflected and it will be sent to Ms. Jackson. It's just while we're trying to sort this out and enter the order in the system that we have this problem. And after that, then he can send in any future payments. It's just, we got to get it sorted out and on the computer. That's why they put a hold in the first place, was to give us an opportunity to have a hearing, but so we could decide where that money was supposed to go. They can add the language. It's always like a legal thing versus a technical thing. And that's what we don't want, these added headaches. So legally, yes, it would make sense outside of the technical part, but we got to work around the technical part.
And Judge, normally we would not put any language in the order regarding where the money on hold will go. It just has to be dispersed according to the law.
Okay.
Okay.
So we'll have to wait and see on the 200180, but this at least takes care of the arrears and then the additional amount, and then we'll see what happens with that. If he wants to send in payments for, let's say, November today, he can do that, but he might wait a week or two before he does that so that they can process these changes.
okay.
All right. The Attorney General's office will draft an order. Ms. Smitherman, can you put your email address in the chat to Ms. Phillip so she can email you the order, the proposed order?
Sure. Is that something that'll be done in the next few minutes, or what's the time frame?
Probably in the next few hours. We have other cases, so it won't be done in the next few minutes.
Okay, I just wanted to know if because I've got court across the street, so I just want to make sure that I have time to go over there.
Yeah, no, it'll be done today, but not in the next few minutes. Ms. Phillips will be
Okay.
doing probably a bench attorney for the rest of the day till the afternoon. So definitely not very soon, but within the next 24 hours.
All right, that'll work.
We're on 24 to 48 hours.
Okay.
Okay, thank you all. Y'all are excused and can press leave on the Zoom to exit out. Thank you.